Good morning, good afternoon, or good evening, depending on where in the world you are joining us from today. Yes, welcome to this first joint webinar co-hosted by the Oceans and International Environmental Law Interest Group of the Australian and New Zealand Society of International Law and the Law of the Sea Interest Group of the European Society of International Law. As you all know, the topic of this webinar is on the very interesting 2023 International Court of Justice judgment on the question of the delimitation of the continental shelf beyond 200 nautical miles between Nicaragua and Colombia, the Nicaragua and Colombia case. So it was not easy to find a time that is convenient for everyone, especially when you have three speakers from three different continents. So we know that it's a bit early for those of you joining us from Latin America and a bit late for those joining us from Australia and New Zealand. So thank you all for joining us today, especially our three speakers. My name is Bruno Arpi. I'm one of the co-chairs of the Australian and New Zealand Society of International Law, Oceans and International Law Interest Group, and I also lectured at the law school and the Institute for Marine and Antarctic Studies here at the University of Tasmania in Australia. So this interest group of the Australian and New Zealand Society of International Law, OILIC, as we know it here, is a forum for discussion and collaboration between members of the Australian and New Zealand Society of International Law, in which we discuss all areas of the law of the sea, international environmental law, and also Antarctic governance. So on behalf of the Australian and New Zealand Society of International Law, I would like to say that we are very proud to be collaborating with the European Society of International Law on this event, where we aim to bring together emerging and experienced academics in a collaborative and stimulating culture of exchanging ideas. Today, Dr. Efthymios Papastavridis from the European Society of International Law will co-chair the event with me. So thank you, Akis. Over to you.
Warm thanks, Bruno, and a very warm welcome and good morning, good afternoon, good evening from Athens, where I'm now based. My name is Akis Papastavridis. Efthymios is quite difficult, and Papastavridis is very difficult, a big Greek name. So Akis is very convenient. I'm a member of the coordinating committee of the interest group of the European Society for International Law on the Law of the Sea, as Bruno mentioned. Along with my wonderful colleagues, Gabriella, Wanda, Jessica Sensiger, and Irene Papanikolapoulou, who is not here with us. We are the four members of the coordinating committee. We have, as the interest group of the Law of the Sea, we have tried to be proactive in many respects. And when the BNJ agreement was signed, we had a webinar. Now we're discussing this very seminal case of the International Court of Justice. We have different kind of activities, hybrid activities that coincide with the annual conference of the European Society for International Law. So probably we'll have one in Vilnius, Lithuania. So watch the space for the announcements. And we all also very much welcome everybody who is interested in the law of the sea and member of the European Society to join us. Now, before I turn to Bruno, just a few words. Firstly, how this evolved. It was thanks to Gabriella. So many thanks to Gabriella, who was the first that actually proposed, speaking with Bruno and the other colleagues from the Australian New Zealand Society, that we can have co-hosted meetings. So we pondered about. We were very happy about this. It was challenging because of finding the right time and the right, that everybody could be present and could have this event organized. We managed to have this today, and we're very happy and very thankful to our distinguished speakers. And as Bruno said, we are speakers are coming from 3 continents. It was our idea to have, people from Europe, a person from, from Australia, New Zealand, and also someone who is closer to the area where this seminal case was decided. Now, this case was chosen as our inaugural discussion because I think it's really important, and I will share this view, and we will all hear about this because it was a case that discussed about whether a state can have an extended continental shelf overlapping with another state EEZ. So very fundamental concepts of international law of the sea. What's continental shelf? What's a maritime entitlement to continental shelf and the EEZ? As well as issues of delimitation, whether this should be, judged by the court, and also issues of customary international law and opinio juris, and all this has prompted various reactions after the case was decided. So we are looking forward to hearing from our learned colleagues about this case and have a very stimulating discussion after the presentation. So I give the floor again to Bruno, and with warm thanks to him and all other members for this coordination, and also for Maria Grazia from the European Society who put all this all together. Thank you.
Thank you, Akis. And I must highlight that Dr. Francis Angadi, one of the other co-chairs of the Oceans and International Environmental Law Interest Group of ANZSIL, helped me, and Joanna Mossop, who is apologize, is also the third co-chair of this interest group. So thank you. So now let me introduce today's panelists. So our first speaker today is Frida Armas Pfirter. So as you know, Frida is a judge at the International Tribunal for the Law of the Sea. She's also professor in public international law at the University of Buenos Aires in Argentina. Yes, before joining the tribunal, Frida was general coordinator of the Argentine Commission on the Outer Limits of the Continental Shelf, where she led the scientific and legal work for the demarcation of the outer limits of the Argentine continental shelf, especially the submission to the CLCS. Yes, Frida also served as an expert in the Legal and Technical Commission from 2001 to 2011, and in the Finance Committee from 2011 to 2022 at the International Seabed Authority. And she's also a conciliator and arbitrator of the dispute settlement mechanisms of UNCLOS, and an expert for the purpose of the special arbitration of Annex 8 of the Convention. So thank you, Frida, for joining us today. Then, yes, next we will move to Hilde Walker. Dr. Hilde Walker is Assistant Professor of Public International Law at Leiden University in the Netherlands. Yes, her research specialization is on the law of the sea, with particular focus on law science interface and the legal regime for the continental shelf. Before joining Leiden University, Hilde worked at the Norwegian Center for the Law of the Sea in Tromsø, Norway, and she has been following the Nicaragua and Colombia cases for more than 10 years, yes, and she published, yes, several pieces on this particular case, including a blog on ESIL Talk, and she has an article forthcoming together with Leonardo Bernard in the International Journal for Marine and Coastal Law. Thank you, Hilde, for joining us today. Yes, and finally, but not least, we will move to Professor Donald Rothwell. Don is a professor of international law at the College of Law of the Australian National University in Canberra, Australia. Yes, his research has a specific focus on the law of the sea, polar law, and implementation of international law within Australia, as reflected in more than 200 publications, including a third edition of his leading work with Tim Stevens, The International Law of the Sea, that was published last year in 2023, and his recent books on islands and international law, published in 2022. Yeah, and also it's important to highlight that Don was rapporteur of the International Law Association Committee on Baselines under International Law of the Sea from 2012 to 2018. So also thank you, Don, for joining us today. So each speaker will have between 10 and 15 minutes, and then we will have the remaining 30 minutes for Q&A. So unfortunately, due to some personal reasons, Judge Armas Pfirter will not be able to remain until the end of the webinar. She apologized for this, but she will be happy to answer any questions regarding her presentation via email. So at the end, we will have a Q&A session with Hilde and Don. If you want to ask a question, you can ask it at any time. Yes, there is a Q&A button at the bottom of your screen. Yes, you can ask them at any time, but we will be putting the questions to the speaker at the end of the presentations. All right, without further ado, let's begin with our first panelist. As an introduction to today's topic, Judge Armas Pfirter will discuss the general context of the jurisprudence on the outer limits of the continental shelf, and she will briefly analyze the treatment of different courts and tribunals on some issues relating to the outer limits of the continental shelf, such as the continental shelf within and beyond 200 nautical miles, relations between CLCS and tribunals, delimitation versus delineations since the entry into force of the convention in 1994. So thank you, Frida, again for joining us today. Over to you.
Okay, thank you, Bruno. Good morning, good afternoon, good evening from Buenos Aires. So for me, it's a good morning. And I'm very honored to be here today. And I want to thank both the European and the Australian New Zealand Societies of International Law for inviting me to share this panel with such distinguished colleagues, Professor Donald Rothwell and Hilde Walker. And I want to give a special mention to our coordinators who have done such excellent work in the organization, and particularly to Professor Bruno Arpi, who contacted me. Allow me to remind the obvious statement that my views, the views expressed in these presentations are on my own personal capacity and do not represent, of course, the opinion of any of the institutions I work for. As Bruno have said in my presentation, being the introductory to this panel, I will give an overview of the important pronouncements of the jurisprudence on the outer limit of the continental shelf since the entry into force of the convention. Therefore, since the three bodies created by the convention, the International Seabed Authority, the Commission on the Limits of the Continental Shelves, and the International Tribunal for the Law of the Sea became operative. Of course, I do not intend to either provide a comprehensive analysis of the cases or cover all the issues they dealt with because time constraints. But as we all are aware, the convention provides that a state is free to choose one or more of the four compulsory procedures for the settlement of disputes mentioned in Article 287. Consequently, there is a plurality of adjudicating bodies on equal standing. The conclusions that I'm going to present are drawn from 9 cases which have dealt with the outer limit of the continental shelf, from the International Tribunal on the Law of the Sea, from the International Court of Justice, and the Arbitral Tribunal. I will leave aside the Special Arbitral Tribunal of Annex 8 on technical issues because there have been so far no cases on it. In relation with the International Tribunal for the Law of the Sea, among the 32 cases presented to the tribunal since the beginning of its work, 3 were related to the outer limit of the continental shelf. Case 16 in 2012, Bangladesh versus Myanmar. This decision is important both because it was the first maritime boundary delimitation adjudicated by ITLOS but also was the first decision ever on the delimitation of the continental shelf beyond 200 nautical miles. Case 23 in 2017, the decision of the special chamber between Ghana and Cote d'Ivoire, and case 28 in 2023, the special chamber also between Mauritius and Maldives. In relation with the International Court of Justice, the court considered 15 cases involving law of the sea since the entry into force of the convention. But these cases were not submitted under the procedures of Part 15 of the convention, but in relation with other treaties that gave jurisdiction to the court. In relation with the outer limit of the continental shelf, I'm going to refer to the first case, the territorial maritime dispute between Nicaragua and Colombia, the judgment of 2012, sorry. Then the one between Somalia and Kenya, the judgment of 2021, and the one that we are considering today, between Nicaragua and Colombia, the judgment of last year. And it's interesting to note that the jurisdiction of the court in both Nicaragua cases was found on Article 31 of the American Treaty on Pacific Settlement of Disputes, 1948, known as the Pact of Bogotá. In relation with the Arbitral Tribunal of Annex 7, there were 14 arbitrations under Annex 7 of UNCLOS, and 3 of them referred to the outer limit of the continental shelf. The one on 2006 between Barbados and the Republic of Trinidad and Tobago, the one on 2007, Guyana versus Suriname, and the one in 2014 between Bangladesh and India. So, analyzing the main statements of the 3 tribunals regarding the topics on the topics regarding the outer limit of the continental shelf in these 9 cases, I wish to highlight the following coincidences among the different awards or judgments. Sorry. Well, first, regarding the legal character of the continental shelf within and beyond 200 nautical miles. This first sentence, that is literal from the Arbitral Tribunal between Barbados and Trinidad and Tobago case in 2006, says there is in law only a single continental shelf rather than an inner continental shelf and a separate, extended, or outer continental shelf. This statement really marked a cornerstone, as all the subsequent decisions reiterate it and deepen this concept, reaffirming that the coastal state exercise exclusive sovereign rights over the continental shelf in its entirety, without any distinction being made in Article 77 between the continental shelf within and beyond regarding the rights of the coastal state. And that we found it in the ITLOS cases, both the 2012 and the 2 from the special chambers, and also in the arbitral tribunals. The International Court of Justice, in the case that we are going to analyze today, perhaps goes beyond that, affirming that in contemporary customary international law, so it's not only the dictum of the tribunal, but the court considers it a customary international law, there is a single continental shelf in the sense that the substantive rights of the coastal state over the continental shelf are generally the same within and beyond 200 nautical miles from its baselines. In keeping with the assertion of the existence of the single continental shelf, regardless of whether it is within or beyond 200 nautical miles, some of the tribunals adequate also the denomination given to this maritime space. Before 1994, the continental shelf beyond 200 nautical miles was usually named as broad or extended. But in 2006, the arbitral tribunal in the Barbados-Trinidad case explained that it considered more accurate to refer to the outer continental shelf, since the said continental shelf was not extended, but extends naturally to the outer edge of the continental margin. Going beyond that, ITLOS, the International Tribunal on the Law of the Sea, from the Bangladesh versus Myanmar case on, only referred to the continental shelf beyond 200 nautical miles, stressing the single nature of this maritime space regardless its extent. That is, without using the denomination outer or any other, only continental shelf beyond or within 200 nautical miles. This criteria is not followed by the International Court of Justice, which also use extended continental shelf. I will now try to summarize the main considerations of the tribunals about the role of the CLCS. UNCLOS sets up an institutional framework with 3 bodies to implement its provisions: the Commission on the Limits of the Continental Shelf, the International Seabed Authority, and the Tribunal. The activities of these bodies are complementary to each other so as to ensure the coherent and efficient implementation of the Convention. The Commission plays an important role, and its mandate is to make recommendations under Article 76. It's important because there is a need of previous submission to the Commission in order that the Tribunal may be certain about the existence of a continental shelf beyond 200 nautical miles. Also, the Tribunal has stated that the coastal state has exclusive rights over the continental shelf, regardless the submission that they made the submission to the CLCS. And it was also acknowledged by the tribunals that the establishment of the outer limit is an unilateral act, but the opposability with regard to other states depends on the limit established by the coastal state on the basis of the recommendation of the Commission. It was acknowledged by all the tribunals that the functions of the Commission and those of the tribunals differ but complement each other. The awareness of the difference and relation between the role of the CLCS and that of the tribunals comes hand in hand with some key aspects of the relationship between delimitation and delineation of the continental shelf beyond 200 nautical miles. In the delineation, we are in the framework of Article 76, the Commission is assigned with the task of making recommendations to the coastal states on matters relating to the establishment of the outer limit of the continental shelf. In the delimitation, according to Article 83, is under dispute settlement procedures in Part 15 of the Convention, which includes the courts and tribunals. And the different awards and judgments coincide in that, on the one hand, the recommendations of the CLCS shall not prejudice matters relating to the limitations of the boundaries. But on the other, the decision of an international tribunal delimiting the outer limit of the continental shelf beyond 200 nautical miles must be without prejudice to the delimitation of the outer limits of the continental shelf. So the lack of delineation of the outer limits of the continental shelf is not in and of itself an impediment of its delimitation between the 2 states with adjacent coasts. The tribunals also refer to third parties that can be affected by the judgment. There was a precedent in 1992, before the entry into force of the Convention, when an arbitral tribunal rejected the possibility of making a delimitation between 200 nautical miles, arguing that this decision will also involve a delimitation between each party and the international community, since the seabed beyond national jurisdiction was common heritage of mankind. It was at the arbitral tribunal between Canada and France. In the cases we are considering in this presentation, the tribunals also affirms that the delimitation of the continental shelf cannot prejudice the rights of the third parties. But in doing so, it says that its decision shall have no binding force except between the parties in respect also to that particular dispute. And as far as the area, that is the common heritage of mankind, is concerned, the tribunal observed that in the concrete case, the continental shelf beyond 200 nautical miles was situated far from the area. This was particularly in the ITLOS, Bangladesh, and Myanmar case. Therefore, the line of the limitation should not prejudice the rights of the international community. In the following judgments, the third states are mentioned in relation to the fact that the tribunals did not determine the outer limit of the continental shelf, fixing an endpoint, but in general, with a general mention that the limit will be until it reaches the area in which the rights of third parties may be affected. This concept of lack of endpoint is reflected in the maps with a line ending with an arrow. We can see here and here. The delimitation line does not end at a given point. The tribunal extended the line from the single maritime boundary beyond the distance until it reached the area where the rights of the third state, may be affected. For example, Côte d'Ivoire, Ghana, Bangladesh, Myanmar. Both these are from ITLOS. But here we can see another example in the judgment from the International Court of Justice between Somalia and Kenya. The court was perhaps more clear and concludes that the maritime boundary beyond 200 nautical miles continues until it reaches the outer limits of the parties' continental shelf, which are to be determined by on the basis of the recommendations made by the Commission, or until it reaches the area where the rights of third parties may be affected. Well, and I'm just on the time, so I hope to have conveyed to you in the short time that we had the important evolution that has taken place in all the aspects related to the outer limit of the continental shelf. At the moment of the entry into force of the convention, there were only few articles and 3 bodies responsible, each one in their own way, of the outer limit of the continental shelf. But with their actions, the tribunals are clarifying and consolidating the answers to many unknowns. It is important to consider that this evolution and the statements of the tribunals was regardless the different situations of each case. I mean, in relation to the Commission on the limits of the continental shelf. For example, in Ghana, Côte d'Ivoire, Ghana procedures before the CLCS were completed, but Côte d'Ivoire had made a submission, but the CLCS had not analyzed it yet. And in the case that we are considering now, Nicaragua has made a submission and is waiting for the analysis by the CLCS, while Colombia is not a party to the convention. I really hope that the harmonious functioning of all the bodies related to the outer limit of the continental shelf and also the practice of the states involved is mentioned, and which is not less important, I think that the tribunals have in general demonstrated a unity of criteria and the different issues that could remove the ghosts of contradictory jurisprudence that was generated with the creation of ITLOS. So as Bruno said, I'm sorry that I cannot stay till the end, but I will be more than happy to contact any of you, to be contacted by any of you. And if you have any questions, here is my mail, or through the organizers, I'm at your disposal to answer whatever you you need. Thank you very much.
Thank you, Frida. Thank you very much for this fascinating presentation. I think that you have created the perfect space for our following discussion. So thank you very much. We know that you will have loved to stay with us until the end of the event, but you have other commitments. So thank you. So as Frida mentioned, you can contact her and she will be happy to answer any of your questions. So thank you very much, Frida, for your contribution to this panel today. Thank you.
Thank you to you.
So excellent. Thank you. So now let's move on to Assistant Professor Hilde Walker. Hilde will discuss how the 2023 ICJ judgment between Nicaragua and Colombia supposedly creates a third constraint line to the delineation of the continental shelf beyond 200 nautical miles. Hilde, thank you very much again for joining us today. Over to you.
Thank you so much, Bruno. And let me begin with thanking the organizers of this webinar. As Bruno said in his introduction, this is a case I have been following for a decade now. So it's a pleasure to be discussing it among such a great panel and with, I'm sure, great participants. So I look forward to the Q&A at the end of our talks as well. Now I'm going to share my screen. There we go. You should all see my slides at this point. Yes, so I have a quick outline. I'd like to begin with a quick history of the case or cases, because of course, as Frida already mentioned, this case started sort of came out of the 2012 judgment between these two parties. We'll then look at the negation of continental shelf entitlement within 200 nautical miles of another state. Indeed, a third constraint, how it relates to customary international law, and then I'll end with some outstanding questions that this judgment raises. So as you may remember, in 2001, Nicaragua instituted proceedings against Colombia to delimit territorial and maritime disputes. We had a judgment on preliminary objections in that case, and eventually in 2012, the ICJ delivered its judgment on the merits and concluded that with respect to the continental shelf beyond 200 nautical miles, it could not proceed to delimitation. Meanwhile, in 2010, Nicaragua had submitted preliminary information to the CLCS. And as you can see in the 2012 judgment, in the first square and then the second square, it's a summary of that judgment in the 2016 judgment on preliminary objections. There seems to be a requirement for Nicaragua to submit full information to the CLCS before proceeding with the actual delimitation. So in June 2013, Nicaragua submits the full submission to the CLCS. Meanwhile, Colombia had denounced the Pact of Bogota to take effect within 1 year. And so within that time frame, Nicaragua instituted proceedings again against Colombia with a specific question of the delimitation of the continental shelf beyond 200 nautical miles. As expected, Colombia raised various preliminary objections, including one with respect to admissibility due to the lack of a recommendation of the CLCS. But ultimately, with a split vote, the ICJ concluded that the request put forward by Nicaragua was indeed admissible. In other words, that we would proceed to the merits on this particular question, namely that of the delimitation of the continental shelf beyond 200 nautical miles within 200 nautical miles of Colombia. In October 2022, the ICJ delivered an order to limit the subsequent oral pleadings to 2 questions, of which the first is presented on the slide. And then, as you know, in July 2023, we have a judgment on the merits where indeed the ICJ concluded that under customary international law, a state's entitlement to a continental shelf beyond 200 nautical miles may not extend within 200 nautical miles from the baselines of another state. In this particular example, Colombia. So let's begin with this issue of the negation of a continental shelf entitlement within 200 nautical miles of another state, because that is indeed one of the findings or the conclusions of the ICJ in this case. And notably, the ICJ did not make this conclusion specifically to the scenario between Nicaragua and Colombia. Instead, it has phrased this conclusion in such general terms that it supposedly applies also beyond this context. So in paragraph 79, we see this big conclusion. Further, the ICJ also explains that even if a state can demonstrate that it is entitled to an extended continental shelf, that entitlement may not extend within 200 nautical miles of another state. The court also explained that regardless of the criteria that determine the outer limit, it cannot overlap with the area of continental shelf within 200 nautical miles from the baselines of another state. And finally, it concluded that irrespective of any scientific and technical considerations, Nicaragua is not entitled to an extended continental shelf within 200 nautical miles of Colombia, and that therefore there is no area of overlapping entitlement to be delimited in the present case. So let's unpack some of these findings of the court. So first of all, what negates a state's entitlement to a continental shelf beyond 200 nautical miles within 200 nautical miles from the baselines of another state? Is it in fact, so in this case, Colombia's continental shelf within 200 nautical miles that then trumps Nicaragua's shelf beyond 200 nautical miles, or is it perhaps Colombia's EEZ in this particular scenario that might trump Nicaragua's shelf beyond 200 nautical miles? The answer to that question is that the ICJ did not elaborate on this and did not actually answer this question. It has been very careful to refer to the area of 200 nautical miles from the baselines of another state. It does not, in the question that the ICJ posed, or also in its conclusion, it did not conclude that it cannot extend within the EEZ of another state. It only concluded that a shelf beyond cannot extend within 200 nautical miles from the baselines of another state. However, in paragraph 282 of the 2023 judgment, the ICJ did say that an extended continental shelf cannot overlap with the area of continental shelf within 200 nautical miles from the baselines of another state. So that implies, perhaps, that an entitlement to a continental shelf within 200 nautical miles is stronger than an entitlement to a continental shelf beyond 200 nautical miles. So in other words, it is perfectly acceptable for a continental shelf within 200 nautical miles to overlap with another continental shelf within 200 nautical miles. In fact, that happens all the time. That's why we have so many delimitation cases. It is also supposedly acceptable for a shelf beyond to overlap with a shelf beyond. But in this particular scenario, we're dealing with a shelf beyond overlapping with a shelf within, where the ICJ then concludes that that is not allowed, that is not possible. And so that also raises the question of the relationship between the EEZ and the continental shelf within 200 nautical miles. The EEZ, as we know, is not inherent. It's a zone that you have to claim as a state, whereas the continental shelf is inherent. So when then the ICJ concludes that a shelf beyond may not overlap with a shelf within, or with any area within for that matter, this question comes up again. And also, Frida already alluded to the concept of a single continental shelf. In light of this judgment, but also various others, this concept is also brought into question, because if we have if we really follow this concept of a single continental shelf, which has been so religiously upheld within the case law, it would not make sense to make a distinction between a shelf within and a shelf beyond. So in this respect, this judgment is again an affirmation that maybe we need to let go of this concept and rather look at the shelf as one maritime zone, but with varying degrees of sovereign rights or coastal state control. So another question that is raised by the judgment is the relationship between delineation and delimitation. These again are the conclusions I had just presented. So what the court concluded is that before even proceeding with any question of delimitation, the court concluded that there cannot be an area of overlapping entitlement, or that an entitlement cannot even extend within the 200 nautical mile zone from another state. So what does this do to the unilateral nature of delineation? Delineation is always a unilateral act. You measure your own extent of the continental shelf from your own baselines. This relates to the next point I'm going to make, that this essentially creates a third constraint. So now when proceeding to delineation, you now have to take into account other 200 nautical mile zones of other states. And indeed, it sort of changes the chronological and the non-prejudicial relationship between delineation and delimitation, because aspects or considerations of delimitation are now brought into the delineation process. And as Judge Tomke and Robertson both said in their own opinions attached to the judgment, maritime entitlements, unlike territorial entitlements, are unique in the sense that it is possible to have competing entitlements over the same area. If those exist, you then proceed to delimitation. And so the court's judgment in this respect seems to move away from that and try to, in a sense, to avoid any issues of overlap and therefore the need to delimit. So another question is whether this judgment creates a third constraint. So for those of you that are familiar with Article 76 of UNCLOS and the very technical and scientific formula lines and constraint lines in how to delineate the continental shelf, very quick recap. On the one hand, we have two formula lines, which you can use to measure the outer edge of the continental margin. And you then have two constraint lines to make sure that coastal states don't claim huge amounts of continental shelf. So this is one of the outputs of UNCLOS 3 of the package deal in a way to balance the rights and interests of the broad continental shelf states vis-a-vis the international community. So we have two formula lines, two constraint lines. You're allowed to use them all to your advantage, and then ultimately you put them all together, and then on the left-hand side of the slide, you can see how the outer limits are then formed. But let's see what this judgment does. So if you look at the left side of the slide, that's where you see the formula lines. Now, all of a sudden, according to the ICJ judgment, we have to take into account a third constraint, namely the 200 nautical mile zone of a potential third state, of another state. So what if, in this example, we had an island here within 200 nautical miles from the coastal state? So this is an island from another state. We have a second island just within one of the formula lines, and we have another big country completely beyond any considerations of our state's delineation procedure. So let's assume that these three countries that I have now inserted into the picture are all three different states from the state that we see at the bottom of the diagram, the state that we're trying to delineate the continental shelf for. So how would that work? If we draw a 200 nautical mile line around this island, would we be allowed to use the foot of the continental slope, that part of the orange line, because it is within the 200 nautical mile zone of the foreign island, so to say. What about if we have an island here? Are we allowed to refer to any scientific data collected within that radius to delineate the outer limits of the continental shelf of our state? And what if there is an island, or sorry, what if there is a big country on the other side that somehow impacts? To what extent should we take into consideration these limits, and more importantly, at what point in the delineation procedure? As you know, the constraint lines, you're allowed to use them to your advantage, and they come into play after you determine the formula lines. But the way that the ICJ has phrased its findings in the case between Nicaragua and Colombia implies that we may have to take into account the 200 nautical mile lines before looking at the formula lines, or even the other two constraint lines. And then finally, I'd like to end with some considerations of customary international law. And I am aware of the time, so I'll jump through this rather quickly. But this is the most notable paragraph in this respect. And I've highlighted here that the ICJ finds that the practice of states before the CLCS is indicative of opinio juris, even though those practices may have been motivated by considerations other than a sense of legal obligation. Therefore, the ICJ concludes that the practice of states may be considered sufficiently widespread and uniform, and in addition, an expression of opinio juris. So one question is whether this contradicts the North Sea Continental Shelf judgment, in the sense that a practice that forms a tradition or a habit is not sufficient to determine opinio juris. But I also think it might be problematic because CLCS submissions are not recognitions of outer limits. When a coastal state submits information to the CLCS, it occurs often, frequently even, that there are disagreements between the submitting state and the CLCS itself, which gets resolved most of the time within the iterative process. But it does mean that only looking at the CLCS submissions is not the final step. And therefore, it is not a recognition of outer limits, and thus the reliance upon those submissions to determine a rule of customary international law is quite problematic. And in relation to that, what about the availability of data? When coastal states submit information to the CLCS, they submit extensive documents, data, files, etc., but only the executive summaries are published online on the website. So how are we even able to determine state practice and or opinio juris from such limited information? And then my final slides just present some outstanding questions that the judgment either raised or did not definitively answer. So indeed, as I've discussed, what is indeed the basis for negating the entitlement within 200 nautical miles? What is this relationship, or how is it influenced by the current judgment between delineation and delimitation? We'll have to wait and see what the practical implications are for delineation, whether there is a third constraint, and whether that third constraint takes primacy over the other two that already exist. This particular situation was governed by customary international law because Colombia is not a party to UNCLOS. Would the ICJ conclusions be relevant also in a situation where treaty law applies? Although, of course, then in those situations, custom also applies. Nicaragua and Colombia are opposite coasts mostly. So the question remains how these conclusions apply in situations of adjacent coasts, and the validity of gray areas that courts and tribunals have identified before. I'm left with a question, why the change of heart and the long wait between the different stages of the procedure? For if this was true, for if there was indeed no overlap, why was that not said in 2016 or even in 2012? And why did we have to wait 10 years for such a judgment? And of course, we still don't know how overlapping entitlements beyond 200 nautical miles in opposite scenarios are delimited, and whether the three-stage approach is an appropriate methodology in that respect. So I'd like to end with these questions. I look forward to Don's presentation and the final Q&A, but perhaps it might have been a better approach to recognize both entitlements, but only give effect to one in the delimitation process, which I think would have been able to avoid some of these concerns that I've had, but not just me. Some of the dissenting opinions have raised the same, and scholars as well. So I think perhaps this might have been a better approach to still reach the same result, but without raising these questions. So thank you so much, and I look forward to the rest of the webinar.
Thank you, Hilde, for this fascinating and very interesting presentation. A lot of questions. So hopefully we will have time to discuss more about your presentation during the Q&A session. But again, thank you. So now we move on to the next member of the panel, Professor Donald Rothwell. Don's presentation will discuss the ICJ judgment from an Indo-Pacific perspective, focusing particularly on its potential regional implications. So thank you, Don, again for joining us today. Over to you.
Thank you, Bruno, and it's a great delight to be joining you here from Canberra this evening. And I'm coming to you from the lands of the Ngunnawal people in the Australian Capital Territory. And I wish to commence by paying my respects to their elders, past, present, and emerging. Can I just congratulate my colleagues for their excellent presentations. Judge Armas outlining, by way of background, the work of the International Court of Justice, the International Tribunal for the Law of the Sea, and Annex 7 arbitral tribunals in the field, and especially as it relates to questions of continental shelf entitlements and delimitations beyond 200 nautical miles. And Professor Walker has really, I think, given a tremendous basis for us to understand some of the critical points arising from the judgment. And I have very little disagreement with many of the key points that were made. So, Bruno, with your permission, I might just commence by actually trying to develop one or two of the points that Professor Walker was making, and then I'll move on to a regional perspective and then make some concluding remarks, mindful of the time and wanting to ensure that we have an opportunity to properly discuss some of these key questions. As has been identified, of course, one of the distinctive aspects of this case is that Nicaragua is a party to the convention, but Colombia is not. And of course, that's an issue that's been raised in a number of the cases between these two countries. It presents a particular dynamic, but I guess for those of us who are law of the sea scholars and practitioners, it provides us with an opportunity to see what the International Court in particular has to say about what is the status of customary international law with respect to some of the critical provisions in the convention that are under consideration in these cases. Now, we know, of course, that previously the court in the 2012 decision in Nicaragua and Colombia made it very clear that Article 76.1 was considered to be customary international law. So one of the questions that I've been thinking about and considering, both in my scholarship and my teaching, is, of course, what exactly is the position with respect to the remaining provisions that sit within Article 76, and especially, of course, the critical elements in 76.4, 5, and 6, which Professor Walker outlined for us, the very technical aspects that ultimately go to the way in which states will seek to make submissions to the Commission on the Limits of the Continental Shelf, and ultimately upon which the CLCS will make its recommendations. Now, to that end, there is some indication, I think, in the judgment that there's a view that really all of Article 76 is reflective of customary international law. But it's interesting to note that Judge Tonka, in his dissenting view, actually directly addresses this point and very clearly indicates that, in his view, he does believe that Article 76 is reflected in customary international law. Now, in doing so, if you look carefully at the footnote, Judge Tonka refers to the work of Kevin Beaumont, published in the American Journal of International Law. And Mr. Beaumont is, of course, an official in the US State Department. And of course, we are all aware of the fact that in December of 2023, the United States, who is not a party, of course, to the convention and has, of course, not made submissions to the CLCS, has now sought to assert an entitlement to a continental shelf beyond 200 nautical miles, of course, predominantly relying upon that entitlement, which the United States believes is reflected in customary international law. The other aspect of the judgment that attracted me on the question of customary international law was in the separate opinion of Judge Ray, who said the following: "What has been agreed by the states in the package deal remains in the text of the treaty. What is not included should continue to be governed by customary international law." And that's at paragraph 17 of Judge Ray's separate opinion. Now, Judge Ray was really exploring this whole issue that we're considering today, and that is what exactly is the situation where one state has a continental shelf entitlement beyond 200 nautical miles and the opposite state does not. But I'm just wondering how that particular position, albeit adopted by one judge on the court, could be seen in terms of filling what some states might believe to be a gap or a vacuum that exists in parts of the convention. And to that end, I clearly have in mind the whole question of offshore archipelagos. Now, the dissenting opinions in this particular case are really interesting to read, and Judge Tonka is perhaps the most extensive of the dissenters. Judge Tonka really uses very strong language in his judgment, in his dissenting judgment, really indicating his significant disagreement with really fundamental aspects of the reasoning adopted by the court in its judgment. And ultimately that, I think, goes to much of the question of the status of customary international law, given that that's critical in terms of understanding some of the key points in the convention. But also, I think Judge Tonka is very critical in terms of the way in which he could not really see how state practice was really reconciled ultimately with the decision of the court. Can I also note the dissent of Judge Charlesworth? Judge Charlesworth picks up on some interesting aspects. One is the way in which Article 82 of the convention is referenced in the judgment of the court and given some weight. And really Judge Charlesworth is really indicating, well, at the end of the day, why is that such a significant factor to be taken into account in terms of whether or not one state would be able to assert an entitlement to a continental shelf beyond 200 nautical miles and be opposed to a state who only has a continental shelf entitlement of 200 nautical miles. So I think Judge Charlesworth is really raising this question as to, yes, we understand the significance of Article 82 in terms of a state being able to explore and exploit the continental shelf beyond 200 nautical miles in due course. But why is that relevant, I guess, to the delineation and ultimately to the delimitation process? And in that respect, I also observed that Judge Charlesworth alludes to the significance of Article 83, and I want to come back to that in a minute or so. Just quickly, Bruno, in terms of state practice, it's really quite interesting, once again, to revert to Judge Ray's separate opinion, where there's quite voluminous attention given to relevant state practice, predominantly from within the Indo-Pacific area, with reference to the extensive set of maritime boundary arrangements between Australia and Indonesia, which predate the conclusion of the Law of the Sea Convention, in which Judge Hui observes the manner in which Australia claimed a seabed entitlement to the continental shelf at the time, framed around, of course, the 1958 Convention, and in doing so, Indonesia's continental shelf entitlement was really quite constrained under those maritime boundary treaties concluded between the two countries in the 1970s. There's also a very interesting reference made to the Torres Strait Treaty, again, another pre-Law of the Sea Convention treaty, in this case between Australia and Papua New Guinea. Moving on then to some contemporary considerations, I think that there are, as we all know, some very contested areas in East Asia and Southeast Asia, whereby states who sought to make submissions before the Commission on the Limits of the Continental Shelf have really had ultimately a consideration of their submissions before the Commission really blocked by the objections raised by other states on the basis that there's a dispute with respect to territorial entitlements or certain maritime entitlements. And really, as a result of that, we have some key submissions made by states before the Commission. And here in particular, I refer to the Malaysia-Vietnam joint submission from 2009, the separate Vietnamese submission from 2009, and the Malaysian submission from 2019, which have been the subject of a very extensive diplomatic exchanges via the Secretary-General, which are, of course, all available on the CLCS website. I was going to walk you through a series of possible scenarios, but Professor Walker has effectively dealt with many of those points, and I'd be interested to discuss those in Q&A. I was going to make some particular reference to questions about islands. So, Bruno, I'll just go to my concluding remarks and then we can move on to questions. So my first concluding remark, which I've sort of alluded to, and that is, what exactly is the implication of this decision for the status of the US assertion to a continental shelf beyond 200 nautical miles, purely on the basis of what the court has had to say about customary international law? And that really, of course, doesn't ultimately go to the critical question between Nicaragua and Colombia, but rather the customary international law status of Article 76 and what legitimate reliance the United States can now seek to place upon the position that it's taken in terms of making a claim to a continental shelf beyond 200 nautical miles, notwithstanding the fact that it's not a party to the convention. The other interesting aspect that occurred to me was the way in which the court placed significance on the importance of the common heritage principle. And to that end, it very much said that the way in which the negotiators at UNCLOS 3 considered some of these issues was that they were very mindful that placing significant constraints on the ability of broad margin states to enjoy extensive continental shelf entitlements needed to be taken into account vis-a-vis the rights of the international community over the area and the principle of common heritage. That then, to me, suggests that there's a significant role here that's expected or anticipated on the part of the Commission on the Limits of the Continental Shelf. And indeed, I would suggest that if you carefully read the judgment, the court might be even saying, well, look, we recognise that the CLCS has some very particular competence in these matters in terms of determining outer continental shelf entitlements beyond 200 nautical miles. And we as the International Court perhaps defer to the expertise and the significance and indeed the role that the CLCS plays under Article 76 of the Convention. The other question I want to raise is that it was noted by the court and especially Judge Tomka that the particular issues that were before the court in Nicaragua and Colombia were actually not ones that were actively considered during the negotiation of UNCLOS 3. And Judge Tomka repeats the well-known indicator that at the time of the negotiation of the convention, it was anticipated that there might only be 30 states who might be able to enjoy a continental shelf beyond 200 nautical miles consistent with the Article 76 formula. And yet, of course, we well know that there are many, many more states who at least have sought to make a claim in terms of their submissions before the Commission. Of course, we don't know the final outcome of those processes, but I think we can well and truly determine that there will be, at the end of the day, more than 30 states who have a continental shelf entitlement beyond 200 nautical miles. And does that raise an issue as to whether or not the fact that these particular questions that the court is dealing with in Nicaragua and Colombia were actually ones that were not properly considered during the negotiation of the Law of the Sea Convention? And to that end, is the resolution or is the solution that the court has come to here one that's in fact entirely consistent with the approach adopted during the negotiation of the convention? And I guess my final point there is that even if one does take a restrictive view of Article 76 of the convention, how is that consistent, perhaps at the end of the day, with Article 83? Article 83, of course, deals with delimitation, and ultimately that was one of the issues that was going to be before the court in Nicaragua and Colombia. But Article 83 does not in any way seek to determine whether or not a delimitation is one that would occur between a state which has a 200 nautical mile continental shelf or a 150 nautical mile continental shelf, or a continental shelf that's well beyond 200 nautical miles. All Article 83 talks about is the limitation between states and their continental shelf entitlements. And so I think that's another factor to reflect upon in terms of determining the way in which the legacy of this case may well be considered. Thank you for your attention, and I look forward to the Q&A period.
Many thanks, Professor Rothwell. Don, excellent presentation, and particularly you flagged up also the very interesting second opinions regarding the case, and also issues that they are, will remain to be seen, specifically when it comes, for example, to the United States submission. So we have, and also may I add my thanks to the other two panelists, excellent presentations, and Hilde and Judge. So let's we have, I think, like almost 20 minutes. There are already questions on the Q&A. I will some of them are extensive. I will try to read them out or try to summarize and kindly ask Hilde and Don to answer. So the first comes from Eureka Isi, which to see you, Eureka, or to reading your question. So the questions goes to the first one is whether the ICJ rejects the comprehensiveness or sufficientness of the UNCLOS, and also by recognizing the rule of maritime entitlement not stipulated in the treaty, and will the ICJ recognize the same rule when the dispute occurs between the UNCLOS parties? Do you want to go one by one, probably, or do you want to, whatever suits you better? I mean, we can. I can read we have 4 questions, right? Or we can read it and then we can actually give you some time to answer. So the second comes from Joanne about the role of the CRCS in the delimitation of the Continental Shelf, and the main aspect of the procedure in which the speech found the literature decision for the tribunals. And the third one is comes from the same person. Actually, thanks, panelists, and then it's about how this decision can play out in the dispute between Morocco and Spain in the Mediterranean Sea and Atlantic Ocean. And also, let me now invite other attendees to put the questions in the Q&A. And we can also, if the time permits, we open also ask our own questions with Bruno to the panelists. have many and questions specifically coming out from your presentation. Hilde, you had all the questions at the end, and I'd like to have answers to all the questions that you asked actually. But let's start first probably with Hilde on the question already put in the Q&A section.
Sure, Akis, thanks, and thanks so much for the questions. I'm not sure I can answer all of them because I think some are, especially the last question, is the disputes between Morocco and Spain. I think that goes beyond the scope of this particular webinar, because of course we're discussing here the case on the delimitation of the continental shelf beyond 200 nautical miles specifically. So I wouldn't dare try to resolve a full dispute between Spain and Morocco, but perhaps Dawn has some other insights with that respect. But let me begin with the first question. So did the ICJ reject the comprehensiveness or the exhaustiveness of the UNCLOS? It's an interesting question because, of course, as Dawn also further elaborated, this was the case decided by customary international law, but I mean, the judgment is very short, but in that very short judgment, the ICJ did rely on the convention a lot. And I think maybe I can use this point to also comment on something that Dawn said. One of the concluding remarks that he had made about the relevance of this case with respect to the US announcement. And it's something that I immediately thought of as well, because the fact that the ICJ relies so much on CLCS submissions, where, of course, until this case, Article 76, paragraph 8, in which the CLCS is mentioned in the UNCLOS, its customary status was, let's say, undecided, as in it was clear that the first couple of paragraphs of Article 76 were certainly customary international law, but there was not yet a widespread consensus that the remaining paragraphs of Article 76 were indeed customary international law. And the fact that the ICJ then put so much reliance upon CLCS submissions, which is it's a procedure open to at least member states of the UNCLOS in fulfillment of their obligations under Article 76, paragraph 8, does that mean that paragraph 8 is then customary international law? Because if it is not, why place so much reliance on that technical procedure? So without explicitly addressing the relationship between customary international law and treaty law within the current judgment, I think it did comment on that relationship or implicitly refer to that relationship. But I'm not sure I would be, I would go so far to say that the ICJ rejected either the comprehensiveness or the exhaustiveness of the UNCLOS. Article 83 is, of course, very broad provision, which has been implemented and developed by courts and tribunals in the past. So I don't think the court's approach is necessarily a rejection of UNCLOS per se, but perhaps an implementation of it that I don't always agree with in various ways. The second question, would the ICJ recognize the same rule when the dispute occurs between the UNCLOS parties? It's obviously something that I had also raised, and I think that will be interesting. We'll have to wait and see. In some ways, it would be interesting. I personally think that UNCLOS, if you follow the rules of Article 76 and 83, you would not have arrived at this conclusion. But regardless, whether or not it is treaty law or a customary basis, customary international law will always be relevant. So even in a case between parties that are members or parties to UNCLOS, you would also still need to take into account customary international law. So that's an interesting scenario, and I think we'll have to wait and see how the ICJ and or other courts and tribunals will address the issue. I think I'll leave it at this. Maybe Dawn, if you want to respond, and if there's any other questions, I think I can comment on that afterwards.
Thank you. Look, I just want to make an observation about the questions concerning customary international law. I think we as international lawyers and law of the sea scholars should absolutely celebrate the fact that we have all of these cases between Nicaragua and Colombia, because of course we've seen now over the course of the last few years, in 2022, of course, in the separate Nicaragua-Colombia case, and now in 2023, the court directly turned its mind to the question of the status of some critical provisions in the convention with respect to customary international law. But we don't in any way, of course, have any definitive judgment at the moment about the status of all of the convention reflecting customary international law. And I think that could be the subject of a separate seminar between the two societies to try to make that determination. But certainly I think the significance of some of these cases is that we now have a much clearer sense on the part of the court, at least, as to which articles are reflective of customary international law. And given that one of the most significant maritime players in the international community is not a party to the convention, that can only be of significance for that particular state.
Thank you both for this first round of answers. I mean, don't probably refer to the anonymous attendees question. Maybe with respect to whether paragraph 77 of the judgment can be seen as a form of double counting, or second, whether scholars identify examples of opinion juris in support of the customary rule and defined by the court of judgment. You may will come back to this if you have any comments also with Hilde. Also by Serena. Serena has posed a question directly to Hilde. Whether it is, according to her view, it is difficult to see an institution or a particular procedure involving such body reflecting customary international law. Maybe the submissions are relatively supporting in of the submission. So, Hilde, you may want to address this question, and we're waiting for other questions that may pop up.
Thanks, Akis. So yes, so the paragraph 77, I was trying to also review something. So can it be seen as a form of double counting? It comes down to the question of how to determine customary international law, right? So that sort of the official theory is that it has two components, state practice and opinion juris, and that they are two separate components. But there are scholars that believe and also base this on jurisprudence that these two are now becoming more and more merged. And that in the ICJ has recognized that in some scenarios, state practice can also form the basis for opinion juris. And I think that it has also been the case here, because it's also hard to say because there's one paragraph. It's a very short paragraph for a very big conclusion. But from that very limited text, I think one can derive the conclusion that the ICJ has used or has relied upon CLCS submissions, both as state practice and as opinion juris. So that's, I think, a yes to the first question. The second question, so have scholars identified examples of opinion juris in support of the customary rule identified by the court in its judgment? And I know that there are discussions that have, or I know my colleague Leonardo Bernard, who I know is watching, and we've discussed this when we were writing our article together. He has analyzed CLCS submissions and to what extent coastal states either stop at the 200 nautical mile line or that they go beyond. But you know, we would have to ask him to jump in. I wouldn't want to paraphrase his conclusions, but I think that the conclusion or the general observation is that most states do indeed stop at 200 nautical miles, which is also what Colombia had put forward in their oral pleadings. But there are some exceptions to that observation. And there is another scholar who has presented, and she did an excellent presentation Holly at a conference in Monaco last year, where she identified that perhaps there are different considerations for stopping at that 200 nautical mile limit, and that it might not be because of a sense of an obligation, but rather sort of a neighborly friendliness, or a comity, or so she eventually concluded that there were very few examples that actually confirmed that coastal states stopped at the 200 nautical mile limit of another state because of a sense of a legal obligation. So that's what I would like to raise in this respect. But the conclusion is that I think it's quite difficult to determine because we only have one paragraph. And I think that's a point I have for most of the judgment, is that some of the conclusions that come out of this judgment are huge conclusions with potentially far-reaching consequences. And due to the fact that there is very little information there, it is quite hard to determine how far those consequences actually reach.
Thank you, Hilde. Actually, Serena asked this to start your comment, but you had, it was a wonderful opportunity for you to elaborate on this. We have a question from a Wonsi team directly to Donald, whether you find fragmentations with decisions on the entitlement of the Continental beyond 300 nautical miles among the different tribunals. So Don, you can answer this question if you want also to comment on previous discussion on international law. Thanks.
Thank you. I guess I just build on Professor Walker's observations, and particularly with respect to paragraph 77. I think the points that I would make is that it is very difficult to conclusively determine, just on the basis of the executive summaries that we have available to us on the part of states making submissions to the CLCS, what has determined, shaped, and ultimately become the way in which a state has made decisions to make a submission to the Commission. To that end, I think we do need to be aware of the fact that some states have faced an avalanche of diplomatic communications through the Secretary-General, which are publicly available on the Commission's website. And to that end, as a result of the significant diplomatic backlash, which has legal consequences, some states might have moderated or taken a more conservative position in terms of the way in which they might be interpreting Article 76, if only just to bring about some certainty with respect to their continental shelf entitlements and the consequences that has with respect to maritime boundary delimitations. The question that's been asked, I think I would respond by saying that this case does raise distinctive issues in the sense that we need to recall that cases that go before any of the ITLOS or Annex 7 dispute resolution procedures are only procedures that are available to parties to the Convention. And so some of the very distinctive issues that we're looking at and that we've been commenting on about customary international law between a state party to the Convention and a non-state party will of course not arise before ITLOS or before an Annex 7 tribunal. Of course, they will make some observations from time to time about customary international law, but I come back to the earlier observation that I made, and that is we should celebrate these cases between Nicaragua and Colombia because of the guidance that they've given to us on some of these critical issues.
Many thanks, Don. So we have a question to Hilde, both Hilde and also to you with respect to the third constraint about the customary rule and defined by the court would seem to suggest that gray areas are impossible as a matter of legal principle. This is also your understanding. So this goes with Hilde. And there's another question by your team. How do you assess the order of the ICJ that confined the pleadings on to two questions? Can we say the ICJ limited the procedural rights of the parties to dispute? So I'll probably go before first to Hilde and maybe then to Don to finish his intervention because we're running out of time. Thank you. So Hilde,
Thanks, Aki, and thanks for the questions. With the first question, I think that would be a logical consequence from the ICJ's judgment that grey areas are indeed impossible, because the conclusion here is that an outer continental shelf cannot extend within an intercontinental shelf. This grey areas usually occur in the context of adjacent coasts, whereas of course here we're dealing with opposite coasts. But the ICJ worded their conclusions not in a limited scenario of opposite coasts. So if we take the conclusions from the ICJ, it would mean that these also apply in situations of adjacent coasts, and that therefore grey areas are no longer possible or valid. But I hope that was clear. I don't necessarily agree with the ICJ's determination in this respect, and I think it is quite problematic, because it would potentially overrule ITLOS's conclusions in Bangladesh, Myanmar, but even the ICJ's considerations, it has also considered the possibility of grey areas. So this is again a question that is left outstanding, as I had already identified in my last slide, and I'm hoping that any potential future judgment in whatever scenario might get an opportunity to clarify and rephrase some of these issues. With respect to the last question, how I assess the order that confined the pleadings only to 2 questions, that's also something that Nicaragua had raised in the oral pleadings, because this is first of all, it's quite unique that the ICJ, seemed to bifurcate the oral pleadings. So it seemed to be the case that the ICJ wanted oral pleadings first exclusively on these 2 questions, and that we would then have subsequent oral pleadings on the remaining outstanding questions. That was already unique. Nicaragua, in its oral pleadings, had also explicitly reserved its rights to further elaborate its submissions in subsequent oral pleadings. And then all of a sudden, as a scholar, I haven't been involved in this case. I've only been observing from the outside, and I was very surprised, first of all, to see that we would be getting a judgment. So no subsequent oral pleadings. And I was even more surprised when that judgment also definitively concluded the case. So Nicaragua had not yet had any further possibility to elaborate its submissions in any oral pleadings, nor did Colombia have the opportunity to elaborate their position. And so it is unique that the oral pleadings in this case have only been limited to those 2 questions, with prominence or primacy for that first question, which, might I add, is also a question in general sense. It is not a question applied to the facts of the case. It is a question phrased in such generic terms that it is only a question of law and not law applied to the facts. Interestingly, ITLOS in Mauritius, Maldives, also posed a similar question to the parties in that case, but there ITLOS phrased the question more applied to the facts of the case and used the names of the parties, for example, whereas the ICJ phrased the question in generic terms. So also in that sense, I think this case is unique.
I would just observe. Yeah, I would just observe that I agree with Professor Walker's thesis, as I think was being put forward tonight, about the possibility of a 3rd constraint line. I would just observe that we need to acknowledge, I think, all of us who sit back and look at the work of the International Court of Justice, that the court is going through an extraordinary phase in terms of its workload. The events of the last few months have been truly exceptional for the court, and there's every indication that the workload of the court will continue to increase. To that end, we may well just want to reflect, as international law scholars and followers of the work of the International Court of Justice, that the court might be beginning to turn its attention to efficiency in terms of its decision-making processes, to try to bring about a quicker, more focused approach in terms of the submissions received by states and ultimately the decision-making process. And as Professor Walker observed at the start of her presentation, aspects of the Nicaragua-Colombia case had been ongoing since 2001. So trying to bring about some resolution of these issues, I think, will be a key factor for the court. That's a good outcome for many cases in terms of decision making. And as I said, I'm sure that that's going to be a factor that is going to be very live for the court at the moment.
Many thanks, Don. Certainly echo that the court is extremely, busy right now, and we have to, take this into account when assessing their cases. So I think we've finished. We're already 4 minutes past our time. I mean, on my behalf, before I give the floor to Bruno, on behalf of the Idris Group on the Law of the Sea of the European Society for International Law, I would like to very, very warmly thank you all panelists, all the attendees. We had more than 70, 80 attendees, and also the people asking very, very insightful questions. So many thanks. I think it's the beginning of our beautiful friendship with the Australia and New Zealand Society, and we look forward to future events. So, Bruno, over to you, and again, my warm thanks to all.
Thank you very much, Akis, and on behalf of ANZSIL, also I would like to end this webinar by once again thanking the three panelists. Thank you very much, Don. Thank you very much, Hilde, and thank you very much, Frida. Yes, excellent presentations. I hope you have all enjoyed today's webinar. So also I would like to thank the co-chairs of the Law of the Sea Interest Group of the European Society of International Law. And finally, I have to also thank the two other co-chairs of the Oceans and International Environmental Law Interest Group of the Australian and New Zealand Society of International Law, Joanna and Francis. Thank you both for all your support and help during the organization of this webinar. And finally, thank you all for joining us today. Hopefully we will see each other very soon for our next joint event. So thank you all and have a good day or good evening or good afternoon. Bye-bye.
Bye-bye to all. Thanks.